All right. So where's 2023 CR 0527, State of Texas versus Sebastian Johnny Castillo? Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense,
Garrett Chirac for the defendant.
are you Sebastian Castillo?
Yes, Your Honor.
All right, you entered a plea on March 30th to count 1, paragraph B, no contest. According to the plea bargaining agreement, punishment is to be assessed at 5 years in the prison. There's an affirmative finding of deadly weapon. State is not making any recommendations to your application. There's an affirmative finding of family violence, and then there's to be no contact with several parties. Did you have a chance to review the PSI report, counsel?
Yes, I did, Your Honor.
State,
Yes.
any objections to the PSI report?
No objection, Your Honor.
All right, the state is silent. So any witnesses, defense?
Witnesses, I just have my defendant.
All right, do you wish to call him?
Yes, ma'am.
All right, can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record.
Sebastian Johnny Castillo.
Defense,
Mr. Castillo, do you want a statement you want to make to the court?
I just like to say I'm sorry to my mom, my brothers and sisters.
How old were you when this happened?
I was 17.
Okay, were there some family dynamics going on in this situation with your step parents and your siblings?
Yes, sir.
What was exactly going on? You recall?
I was being beaten and I got kicked out.
I'm sorry, you were being what?
Beaten. No further questions.
All right, who are you saying was beating you?
My stepfather.
And where's the proof of this?
Just his, were any police reports made on this?
No.
Well, did he tell the school?
You tell the school you were getting beaten?
I was kicked out and they went to withdraw me at the school and the cop was there, and whenever they were taking me back home, they kicked me out and I was out for 3 days.
No, my question still has not been answered. So he's saying that his stepfather was beating him at the home. So did he ever report it to the school? That's either yes or no. All right. So where's the proof? Because what I have is I have him going to a home. I have him where they say that he threatened to shoot up the school. That's why the mother called. And then I have him going back to the home and they're saying that he pointed a gun on them.
Judge, I'm saying here that I think what led to this was they, for some reason, the step parents wanted him out of the situation. He denies that he ever made a threat to shoot up the school. He says that was a false threat. I think they just wanted him out of the house. When this happened, you were actually living with your grandparents. Is that correct?
Yes, sir.
And if you get probation, that's who you would live with?
Yes, sir.
And when this happened, you were what, 17?
Yes, sir.
And do you do any alcohol or drugs?
No, sir.
Now, according to the police report, it says S1 and S2. S1 grabbed a handsaw and you're S1. It says S1 grabbed a handsaw and attempted to saw through the lock to the gun safe. S1 then found a grinder and cut through the lock. S1 and S2 grabbed multiple guns from the safe and gathered them together. The cousins who went with S1 were waiting outside the laundry room with guns in their hands. S1 and S2 also gathered other listed items as well. Victim 3, 4, and 5 were all sitting in the living room sofa. Victim 3 said that S1 and S2 went into the living room and kitchen and had some of the guns pointing at them. S1 told victim 3 to shut the F up or he will shoot them. S1 and S2, along with S1's cousins, left the location with all the items he took. Once they left the location, V3, which is victim, locked the doors. Victim 2 arrived shortly after and called out to victim 3 to open the door. That was when victim 3 told victim 2 what happened. Victim 2 then called victim 1, who called the police to make a report. So anybody want to address that? Because victim 3 is a juvenile. Victim 4 is a juvenile. Victim 5 is a juvenile. So
You're shaking your head.
No, none of
are you
that.
saying you didn't take these items?
No, ma'am.
I mean, it's what you pled to. All right. Is there anything else?
Nothing further, Your Honor.
All right. I'll hear argument.
Judge, at the time of the incident, the defendant was 17 years old. It typically it sounds like it was a family dispute matter. Allegations are of guns being pointed, no shots were fired. It's evident that the parents and stepmother and stepfather do not want him in the location. That's not a problem. He's young. He's got his whole life ahead of him. I think he realizes he made a mistake in that situation. Maybe his anger being removed from the family caused him to kind of have a moment of basically being stupid.
And see, I can understand his position if there were people in the home where this was not their stepfather as well. So this is what the court is going to do. Court is going to find you guilty, sentence you to 5 years in prison, give you credit for any time served. There's an affirmative finding of deadly weapon, an affirmative finding of family violence. There's to be no contact with regards to the restitution amount. The court does not, they're asking for $45,000 in restitution. The court has nothing before it to suggest that restitution should be $45,000, and no information on restitution has been presented to the court. So the court is not ordering restitution. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. You won't probably want to go around. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is an affirmative finding of family violence, and also because this is a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. I know we're off the record. I know you're young, and 5 years seems like a lot of time.
Yes.
Time does go by quickly, but you need to start bettering yourself. If there is some type of mental health issue going on, or some other issue that you have, drug issue, or some type of trauma that you've suffered, you can ask for help and they will give it to you. Do you understand?
Yes, Your Honor.
All right, good luck to you. 5795, State of Texas versus John Leo Closa. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense?
Adele Silver for the defense.
Are you John Leo Closa?
Yes, ma'am, I am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney?
Yes,
Did you understand it?
Yes, I did, ma'am.
Are you the same John Leo Closa who was placed on deferred adjudication in 2021 CR 5795 for the offense of assault of a pregnant person on August 31st, 2021 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7, on or about the 30th day of April 2023 in Wilson County, Texas. The defendant, John Leo Closa, departed Fair County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True, ma'am. The state will waive and abandon the other allegations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
Yes, Your Honor, the agreement, should the court follow it, is to deny the motion and to alter and amend the conditions to add hostility and aggression management course and the family violence impact panel. And with those additional conditions, that is the.
All right, why are we needing hostility management and anger course and family violence impact panel when he was supposed to be doing the BIPP course?
He has finished the BIPP course. It was finished last year. Yes, and then there's a new allegation of a new number one in Wilson County. It is still pending.
So why should I continue him on probation? I don't understand. He leaves the county without permission. I'm not even going to consider the fact that there is a pending case in Wilson County because you all didn't go on that. But I do have the state and you all agreeing to hostility management course and the Family Violence Impact Panel Live. So I'm trying to figure out why shouldn't I not just send him to prison?
Well, he has completed many of the things that he had to complete, and he's only 2 years in, so he has 3 more years to go on his probation.
Why is he leaving the county without permission?
It was 25 minutes from his home. I mean, technically it still is out of the county, but it's 25 minutes from his home for a family function with his family.
State?
You're right. I think in the hostility and aggression management course, they do teach some different skills than you learn in the matters intervention course. And I think that maybe with these new skills, they could serve the defendant well and that he could complete the rest of his probation successfully.
All right. This is what the court will do. Is there anything you wish to say, sir?
Ma'am, I apologize for my actions and I won't mess up again. If you please can give me this opportunity to prove to you that I can do better, I will, ma'am.
All right. This is what the court will do. Court will deny the motion, alternate amend conditions to include hostility management course, family violence impact course live panel, and 10 days in the Bexar County Jail as a condition. All right, so you're going to go into custody today, serve your 10 days in the Bexar County Jail. And what you need to remember is you have to follow the rules of the court. Do you understand?
Yeah.
All right, so immediately upon your release, you need to get in touch with your probation officer, and you need to remember you're not allowed to leave the county. You understand?
Yes, ma'am, I do.
And you need to remember that the rules of this court are the rules of this court, because this contract is not between your attorney and the state. This contract is with the court. Do you understand?
Yes, ma'am.
All right, good luck to you. 20 CR 10019, State of Texas versus Eric John Orta. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Eddie Garcia from Mr. Orta, Your Honor.
And are you Mr. Orta?
Yes, ma'am.
Showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Eric John Orta who was placed on deferred adjudication in 2020 CR 10019 for the offense of assault of a pregnant person on April 6, 2021 for a term of 2 years and extended for a total of 2 years? Is that you?
Yes, Your Honor.
State?
Your Honor, the state will be proceeding on a violation of condition number 15G in that on or about the 14th day of June 2023 in Bexar County, Texas. The defendant, Eric John Orta, did then and there fail to register for or attend battering intervention prevention program with an approved agency in violation of condition number 15G.
How do you plead to that? True or not true?
Sure.
State?
The state would waive and abandon all other violations.
Any objections?
None, Your Honor.
All right, did you understand by pleading true to violation of 15G, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of 15G? And do you understand that any agreement that you have come to with the state, the court does not have to follow that agreement? Do you understand that?
Yes, Your Honor.
And knowing that, you still wish to plead true to 15G?
Yes, Your Honor.
Court will find 15G true. What is the recommendation from parties?
Your Honor, the proposed recommendation would be for the court to enter an adjudication of guilt and sentence the defendant to 2 years in the prison.
All right, is that the agreement?
Yes, it is, Your Honor.
Why should I sentence him to 2 years?
Your Honor, the agreement would take into consideration the two new number ones that were alleged Council did tender an affidavit of non-prosecution from the complaining witness today. The complaining witness in the assault, family second, is the same complaining witness on this, on the underlying charge in this MTR, Your Honor. And she was uncooperative at the time that the underlying case was resolved as well.
And more specifically, Judge, she said that she lied about it. Handed an affidavit this morning that she sent to my client's mother, handed it to Mr. Herrera, and she reviewed it. So.
What has he done on probation?
Well, he's completed several, well, I let probation speak about.
Okay.
Your Honor, it appears he was in drug court and he finished that. Other than that, I don't have any other completion. There were several failure to submit on his drug tests. He did not complete the BIPP course.
He says he completed lifetime recovery. I don't know if you have any.
And outpatient program.
Mhm. See, I don't know, did felony drug court accept him?
Let me double check.
Because I do see where he was sent to lifetime recovery. Did felony drug court accept you?
Yes, initially they did, Your Honor.
All right, do you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. You're going to need to speak up. State your name for the record.
John Orta.
All right, so what do you mean that felony drug court initially accepted you? What happened?
They had accepted me, Your Honor, and I didn't comply with one of the rules of not, I believe, coming in and continuing the program with them. At that moment, they had made me MTR. I came and I did the 90 days of lifetime recovery. And then once I came out of lifetime recovery, I finished the after program. I followed all the rules of that. I stayed sober. I'm still sober to this day, ma'am.
Why didn't you do the BIPP course?
Ma'am, honestly, I just didn't get to it. I just wasn't thinking about it. And that is a horrible decision on my part. And I don't have an answer to give you for that, ma'am, as far as any excuse.
If I may.
Yes.
Yes, right. Due to non-compliance, he was discharged from the drug court program. He did finish the 90 days in lifetime recovery.
Okay. Is there anything else that anyone else would like to say?
Nothing from this.
You can just ask the court to follow the agreement, Your Honor.
All right. The court is going to grant the motion. The court is going to find you guilty. Not grant you community supervision. There's an affirmative finding of family violence. The court will sentence you to 4 years in the prison. Give you credit for any time served. There's to be no contact with Jessica Nava, Nava, and states you're dismissing the assault family second and the criminal mischief charges.
Correct, Your Honor.
All right, the court will take in consideration NITMAG number 799937, which is the assault family second, and County Court Cause number 710566, which is the criminal mischief case.
Judge, would you reconsider, based on the violation that he pled to, it seems like the punishment of 2 years would be more appropriate than the 4 years that we were wanting to sentence him to. That's the reason that we entered into this agreement, is based on this violation.
All right. All right, the court is going to keep the sentence at 4 years. The court will give him credit for any time served, credit for any inpatient treatment. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates in the allegations in the motion. Counsel. That's that. The limited right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Today's courtroom session unfolded like a masterclass in justice, methodical, intense, and deeply human. It began with the case of Vonzel Hall, standing trial for the most serious charge of all, murder. The prosecution revealed a straight offer of 35 years in prison, and Judge Raquel West wasted no time in laying out the stark reality before him. She gave Hall 3 choices: accept the deal and lock in 35 years, choose a 40-year sentencing cap directly from her, or risk everything in a jury trial. Her explanation was clear, calm, and deliberate. There was no drama, no distractions, just the plain truth of what was at stake. For Hall, this wasn't just paperwork. It was the defining crossroad of his life. Next came Lendra Addison, a man already on probation for burglary of a habitation. Probation, as Judge West reminded, is both an opportunity and a responsibility. Addison's violations, failing to report to his probation officer, might sound small, but in the eyes of the law, they were enough to break the trust the court had placed in him. The state agreed to drop several allegations, leaving just one violation. Addison admitted it was true, and Judge West swiftly revoked his probation, sentencing him to 4 years in prison. Yet even in that decision, she was careful and thorough, confirming that Addison understood his rights, his paperwork, and even his restrictions on firearm possession. It was firm justice, carried out with precision. Finally, the session turned to Toy Hill, charged with assault on a family member by restricting breath, an offense the law treats with utmost seriousness because of its dangerous, intimate nature. Hill entered a guilty plea, which secured a deal: 10 years of probation, a $500 fine, and strict compliance with court conditions. But what followed revealed the judge's deeper role, not just as a legal authority, but as a protector. Concerned about Hill's relationship with the victim, her own mother, Judge West imposed strict bond conditions. Hill could live with a friend, but under no circumstances was she to contact her mother. Not in person, not by text, not even if her mother reached out first. The message was crystal clear. One slip, and the entire deal could collapse. Through each case, Judge West demonstrated what makes a courtroom run with integrity, clarity, balance, and absolute fairness. She didn't just rule, she explained. She didn't just sentence, she ensured defendants understood the weight of their choices. It was justice in motion, not flashy, but steady, deliberate, and impactful. If you found this hearing as shocking and eye-opening as we did, then make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Justice is not always loud. It's in the careful, deliberate moments that shape lives forever.